Check bounce in 2025. In simple words, a check is an order to a bank to pay a particular sum of money from the account of the issuer of the check, written on a specifically printed form. The issuer of the check is called the drawer, while the person to whom the check is issued is the bearer. The bank that holds and transfers the money for the drawer is called the drawee. Federal Decree Law No. 50/2022, issuing the Commercial Transactions Law, lays down various provisions regarding checks. Article 514 of the law defines a check as a commercial paper with an order issued by the drawer to the drawee bank to pay on the date fixed therein as the date of issuing a specific amount of money to a third person, namely the beneficiary, or to bearer. Even with the advent of payment technologies and various online payment options, checks continue to be widely used in the UAE, especially in the real estate sector. They provide a secure way to transfer money between two people. Due to the large expatriate community in the region, securing future payments becomes a hassle, which is solved by issuing checks that can be paid as and when the payment is due. Furthermore, strict legislations around checks and check bounce cases contribute in making checks a reliable way to transfer money. Bounced checks can result in both civil and criminal proceedings against an individual. Article 627 of the Commercial Transaction Law lays down various conditions required to issue a valid check. The word check must be written on the check in the same language in which the details of the check is written. The payment of money must be unconditional. The check must contain the legal name of the person, drawer, issuing the check. The check must contain the legal name of the entity, drawee, obliged to make the payment to the bearer of the check. The place where the payment is made must be mentioned on the check date, and place of execution of the check must be mentioned in the check. The check must contain the signature of the executor of the check, and which must be identical to the standard signature on record with the bank. Additionally, as per Article 629 of the law, the bank must draw a check that has been issued and is due in the state. The check must contain the name and the account number of the account holder, i.e., the drawer of the check. The check must be encashed within 6 months of its issue, as per Article 649 of the law. If the check contains all the above-mentioned information, it will be issued by the bank without any hassle, unless the bank account of the drawer does not hold sufficient funds, as agreed in the check, or the bank has been issued a protest by the drawer, also known as an order for stop payment. When a bank refuses to cash a check due to insufficient funds, a stop payment order, or due to a check not meeting the essentials mentioned above, the check is said to have bounced or dishonored. Provisions governing check bounce cases have seen sweeping changes in the UAE in the past few years. Earlier, check bounce cases were treated as a grievous crime, and the drawer of the check faced possible jail time or fine. The older criminal provisions thus placed an undue burden on the UAE criminal justice system. The new laws have made significant changes in the treatment of check bounce cases. Check bounce cases can now be treated as civil or criminal cases, depending on the circumstances around the case. Article 630 of the Federal Decree Law No. 50 of 2022 states that no check must be issued unless the drawer has sufficient funds in his account that can enable the honoring of the check, in accordance with the agreement made at the time of issuing the check. As per Article 648 of the law, if the account holds funds less than what is prescribed in the check, the bank may pay the available funds to the bearer of the check, unless the bearer rejects it. The drawer may issue a protest or a stop order to the drawee bank only in cases of loss of check or bankruptcy of the drawer, as per Article 651. According to Article 667 of the law, if a check is dishonored as a result of insufficient funds in the bank account, the check will be considered an executive instrument, and the bearer has the right to execute the check by force, as per civil procedure laws. As per the new laws, check bounce cases in the UAE have evolved from a criminal offense to a civil matter with heightened financial penalties. Issuing a check with insufficient balance in the bank account does not automatically lead to criminal liability anymore. Instead of reporting to the police in case of check bounce, one may now directly approach the court for an execution order for full payment, or the payment of the remaining amount, in cases where they have chosen to accept partial payment from the bank. This alternative ensures that the bearer of the check has a quicker way to recover funds. Cheque bounce will be considered a criminal offense in the following instances, as per Articles 673 to 684 of the Federal Decree Law No. 50 of 2022. Lying about insufficiency of funds or leading to dishonor of checks, even though there are funds in the account, will lead to a fine of not less than 10% of the value of the check, with a minimum fine of AED 5,000. Intentionally issuing a check with the knowledge that there is insufficient fund in the account leading to dishonor of check can lead to fines of not less than 10% of the value of the check, with a minimum of AED 1,000. In case of repetition of the offense, the fine will be doubled. Instructing a bank to dishonor the check for fraudulent reasons, fraudulently closing the bank account or withdrawing the full balance before the presentment date, or intentionally causing the freezing of the account in any way will lead to imprisonment between 6 months to 2 years and/or fine of 10% of the check value of a minimum of AED 5,000. Repetition of the offense will cause the penalty to be doubled. Intentionally signing or executing the check in a way that will cause the rejection or the dishonor of the check will lead to imprisonment between 6 months to 2 years and/or fine of 10% of the check value of a minimum fine of AED 5,000. In case of repetition of the offense, the penalty will be doubled. Forging a check or tampering with the check to attribute it to a third party, knowingly executing such checks, or knowingly accepting money issued as a result of such checks will lead to a minimum imprisonment of 1 year and a fine between AED 20,000 to AED 100,000. Similar punishment will be levied for committing any acts related to check forgery, such as importing, acquiring or selling equipment or software that is used in forgery crimes. Fraudulently using or benefiting from a check that is drawn in the name of a third party or whose use is associated with a fraud will lead to a minimum imprisonment of 1 year and a fine between AED 20,000 to AED 100,000. The news laws around check bounce cases represent a significant step towards streamlining the legal process and reducing the burden on the criminal justice system. These changes also help in swifter recovery of funds, wherein the issuer of the checks can focus on the return of money, rather than the stringent criminal liabilities that they were subject to earlier. The aggravated fines will serve as a deterrent of the crime, thus ensuring a fairer outcome to all parties involved. It is always advisable to seek guidance from the best lawyers in Dubai to handle check bounce cases effectively and ensure compliance with UAE laws.
For more of our latest updates, like and subscribe to this channel.